This is a brief review of the legal mandates that protect students within educational environments and society at large. So before you start, make sure that in front of you, you have the KWL chart that was provided in the folder. Stop the screen and briefly write down what you know. Do you know the 13 federally defined categories of disabilities for which a student might be eligible for educational services? These are those. The question we always want to ask ourselves is, are labels helpful? So with that in mind, this is a review of many of the historical laws and regulations put into place in the mid-20th century, and to some extent to remember why it's important that we look back on these as we go forward in the 21st century in education. Public Law 94-142 is the keystone and was enacted in 1973. It has been called the Bill of Rights for Children with Disabilities, and it's basically considered the legislative heart of special education. It came out of the civil rights movement of that era and was an amendment to Johnson's Elementary and Secondary Education Act of 1965. It is also the legal foundation for a student's individual education plan. Its purpose was to ensure all children with disabilities to have available to them what's considered a free and appropriate public education, which emphasizes special education and related services designed to meet their unique needs, as well as reassuring children's rights, as well as their parents. It was developed to assist states and local education agencies to provide education for all children with disabilities and to create assurances in which there were effective efforts to educate all children. There are 6 principles, basically, that govern IDEA. Zero reject, which ensures all children have free and appropriate public education provided at the public's expense. That non-discriminatory evaluation is available. And again, going back to this concept that free and appropriate education is available and it is outcome-oriented. The children be educated in the least restrictive environment. That there is a procedural due process in which both schools and parents are accountable to one another, and resolution of any disputes can go forward within realms of mediation, hearings, and possibly litigation. And that there is not just student participation, but parental participation in the process. So what I'm going to hear in this particular slide set is really kind of looking at how this legislation for public law has gone forward with its amendments and in the changes subsequently over the years that have taken place as a result of those amendments. In 1968, this amendment to PL 94-142 affected the education and services for young children those children who were considered preschoolers from the age of 3 to 5 were now included, as well as children from birth to age 2. It's really important to note that in this public law that families are really the strongest participants and givers of services with the support of professionals. In 1990, the amendment changed the name to the public law to Individuals with Disabilities Education Act, or as we still tend to refer to it as IDEA. The amendments also included the individual transition plan be required within a child's individual education plan by the age of 16. Most school districts, in actuality, create these transition plans as early as a child who is 14 years old in order to look at what the plans are going forward for that child as they go into late adolescence and early adulthood. It also expanded related types of services and added 2 categories, autism and traumatic brain injury, as distinct disability categories. It also states that states are held accountable to implement the law. Again, the amendment in 1997 really discussed disciplinary considerations and how the subsequent services for children who had behavioral issues needed to be of humane as well as behaviorally based changes. Related services were expanded to include things like orientation and mobility services for individuals and different types of mediation procedures for both parents and school districts continued to develop. Performance goals and accountability were also within the cornerstone, and federal funding changes were made. It's interesting to note here that this act has never been fully funded since its inception, and it is considered an underfunded mandate even today. I'm going to let this short video run so you can get a sense of some of the consequences as to why additional legislation has been needed within our national level because of the way oftentimes children are treated.
The 8-year-old, identified only as SR, was 3.5 feet tall. He weighed 52 pounds when this video was shot by a school employee.
I asked you not to kick.
Kevin Sumner, a Kentucky sheriff's deputy and a school resource officer who handcuffed the 3rd grader above the elbows, the child's wrists were too small, now faces a lawsuit filed by the ACLU along with his supervisor.
Now, you either behave the way you know you're supposed to, or you suffer the consequences. But it's your decision to behave this way.
SR is a special needs student at Latonia Elementary School in Covington, Kentucky. According to the lawsuit, he suffers from ADHD and trauma.
You don't get to swing at me like that. You can do what we've asked you to, or you can suffer the consequences.
As a parent, I was shocked and hurt for that child. I had a lot of questions. Why would that ever be okay?
Sumner is also accused of handcuffing a 9-year-old girl, also a special needs student, on 2 separate occasions last fall. The lawsuit charges that both children were unlawfully restrained and handcuffed at school with excessive force and without necessity.
Sit back down.
Sumner's attorney told a local newspaper that he handcuffed the children because they were placing themselves and other people in danger, and that's what the book says to do. The attorney also called Sumner one of the best and most highly trained school officers in the state, adding that the former teacher is totally devoted to kids and schools and education.
If you want the handcuffs off, you're going to have to behave and ask me nicely. And if you're behaving, I'll take them off. But as long as you're acting up, you're not going to get them off.
Celebrate the 4th with Jewel, Barry Manilow, Martina McBride, Kenny Loggins, Andy Grammer, Carlos and Cindy Santana, CeCe Winans, Pat Benatar, and Neil.
Thank you for your patience with that. It's really quite disturbing to actually see, and now you understand why oftentimes we have to resort to litigation in order to get laws changed for the rights of these children. In 2004, education services, special education services, were looked at to have some additional alignment with what was considered at the time national school improvement efforts. We formally had looked at identification of students with learning disabilities through the lens of waiting to fail policies. And the subsequent research, as well as changes in the law, purported the use of response to intervention in order to ensure that children are supported for successes. This law also spoke to the qualifications of special education teachers as well as all education teachers. And the details also talked about due process, the evaluation of students, and assessment participation by the students in their own language, as well as the assessment process to include the parents. The mandates certainly look at the different types of provisions that we want to see once a child is referred to evaluation. What we really wanted to look at is the eligibility of services is not just blindly applied, but that evaluation processes ensure that everything is being done for the success of that child in a general education setting. To speak really quickly about the history of the Elementary and Secondary Education Act of 1965, this law was, again, came out of the era in which our country was looking at what equity and quality of education was for young people, especially those who were in poverty. So this law represented a new commitment by the government, by the federal government, for the education of children. There have been subsequent amendments to that. It has a long history, obviously, but in 2001, we look at things like annual testing comes into play, public has access to school performance testing, and it also provided parental choice when parents did not feel that schools were meeting annual progress goals for their child. The initiative for Common Core state standards was within this act, and over time, some states had adopted it and some states had not. In 2015, again, we see a reauthorization of ESEA. And the changes, as I had mentioned before, were that Common Core standards were not a requirement by federal law for states to apply. The concept of highly qualified had always been controversial, and that status was eliminated. And it did allow for state intervention for low-performing schools. So now we turn to some of the really key special education court cases, including the latest one that the Supreme Court took up in 2017. This is a list of some of the most significant that really do require much more in-depth reading right now. But it has to do with how we look at and legislate due to litigation, improvement in how we educate children. Probably the most significant Supreme Court decision in many years that affects education comes from the case of two parents who brought against the Douglas County School District in Colorado a suit because they did not feel that their child was maintaining improvement in school. They found that he had come home oftentimes with behaviors because of his exposure to other children who were dealing with also significant behavioral challenges within a special education setting. The parents took him out of public school and put him into private school, where they did see him improve significantly. So as a result, they turned to the Colorado Department of Education to recover the private school tuition, which was approximately $70,000 a year. That district court said no. And so as a result, the parents took this case up into the Supreme Court, which was then took the case upon themselves in 2017 to rule. The primary questions of this particular court case was that schools must provide a meaningful education in which children show significant progress and also are given subsequently equal opportunities as others, their peers, typical children, or do we just provide an education for these children who have learning challenges and learn differently? Do we just provide them an education that results in just some improvement? So Justice Roberts took the mantle of writing the position paper, and he felt that a child educational program must be appropriately ambitious in light of his circumstances, and that every child should be given the chance to meet challenging objectives. Really what he looked at, and using the language of the fact that the student had been offered what was really a, quote, de minimis, or, the child was provided an educational program that in which he really made de minimis progress, which was the minimum. And in looking at that, he felt that the instructional quality was too low for that child to just simply be left literally behind. It has its consequences in how we look at ourselves as educators and what we need to do to provide quality education for all of our children. Other federal laws that are significant within special education services are things like entitlements and anti-discrimination. The 1973 Rehabilitation Act really looked at how we provide vocational rehab services to people in order for them to work. And that has continued on when you see how the changes in individual education plans have been made to create vocational or transitional programs from adolescence into young adulthood. Technology-related assistance allowed states, and this is in 1988, to create systems to deliver, at the time, that was called assistive technology devices for those with disabilities. One of the most sweeping pieces of legislation of 1973 was really the broadening of the eligibility for those people who were no longer in the education system and were covered under IDEA, but really afforded the fact that that individuals are provided full participation and activity in programs, including school, and how we create the appropriate accommodations and access for those people for the length of their lifespan. So when you look at ADA, it's a civil rights law that prohibits discrimination against individuals with disabilities in all areas of life. The expanded definitions also went on to include those who had AIDS, substance abuse issues, or any kind of impairment that limits a major life activity. It has the consequences for employers, mass transit systems, and other companies to provide services for accommodations for those with disabilities. In 2008, ADA was reauthorized. There was a slight change in terms of what it looks like in terms of the Americans with Disabilities Act amendments, or ADA. And it's really the broader interpretation of what a disability is. And it includes activities such as reading, concentrating, thinking, or bodily functions such as how our immune system or neurological system is functioning. Oftentimes the interpretation of substantial limitation is made without consideration of the measurement of medical equipment. So really what we look at in the effects of legislation is the fact that if we need to change it, litigation becomes the process in which we implement legislation. We will look at school attendance as the right of every child, and the fact that oftentimes special education services are not provided for students whose parents want it. Litigation is also often used when students are assigned to special education services when their parents believe they do not want it. And so parents do go to mediation or ultimately litigation in order to change that. Litigation historically has also involved the use of IQ and standardized tests on certain groups in our society in which standardized tests are not standardized on. Um, in 1992, an example is that in the Hudson versus Rowley case, appropriate education didn't necessarily mean that the child achieved maximum achievement. So when we really look at more often than not the types of things that come into play in the litigation process is the fact that there are issues with assessment, there are issues in terms of funds available to support children. It may include things in the nature of what we look at in how people are viewed, so or not viewed. So we do see a variety of reasons why parents do feel that they are not in sync with what the school is letting them know. So again, a lot of times we look at litigation in terms of the use of and the use of non-discriminatory assessment. Most court cases in this part of the field have dealt with the either the timely delivery of assessment, delays, it's not done within a certain time frame, or the fact that the tests are viewed as discriminatory or not providing a whole picture of a child. The primary issue is that the extent to which the assessment practices often lead to overrepresentation. We see that in much of the label of emotional behavioral disturbance, in which we see a vast overrepresentation of Black children, larger than what the evidence would seem to be across an entire population. We also see overrepresentation issues with regards to dual language individuals, and many times that's as a result of the fact that assessment instruments were used not in that child's primary language. In 1997, there were added provisions for students whose primary language was not English due to litigation and the fact that now we must provide in their child's native language and some kind of measurement of disability rather than looking at their English proficiency. And when we talk about the process, parent participation is extraordinarily important. Parents are the partners in which the cornerstone of a child's education really is foundational. Parents need to be fully informed of all educational activities, including evaluation. There has to be an informed consent provided in native language or some mode of communication if that parent does not speak English or does not use oral language. And accommodations also need to be made for parents, again, who are disabled as a result of hearing issues. Parents must be notified of any action by the local educational agency regarding an initial evaluation and the other options that have been considered other than just evaluation for the for the term of actually placing that child within the realm of special education services. We'll see you again.